I think we are live now. Um, Hello, everyone. Thank you for joining us today. I'm Dr. Kamel El Hilali, consultant on AI and the rule of law at UNESCO. I have the privilege of moderating this important discussion today, organized by UNESCO, the Superior Council of the Judiciary of Colombia, the International Association of Women Judges, and EJTN. We have a record number of registered participants, which shows that this conversation is timely and needed. AI offers many opportunities and raises new challenges, including in the justice system. Some jurisdictions across the globe are taking initiatives and measures to either develop their own AI systems, develop guidelines, improve their productivity, or adjust their decision-making processes to the use of AI by external parties. From case management and mail drafting to evidence, the scope is broad and the questions of critical importance. Judges are at the forefront of this AI transition. Their understanding and ability to both use and evaluate AI systems is essential to maintain trust in the justice system. We will discuss all of those today. We have a brilliant lineup of speakers that I will introduce very briefly before starting this conversation. So first of all, our speakers will deliver some opening remarks. Among them are Mr. Pratik Sibal, who is a program specialist at UNESCO, working at the communication information sector. Mr. Afid Boulakras from the European Judicial Training Network, EJTN. Mrs. Natalia Gaona Cifuentes from Colombia's Superior Council of Judiciary. Then we will have individual presentations from Mrs. Vanessa Diaz Rodriguez, a legal tech expert from Mexico, who will present Sor Juana. Mr. Edouard Rothier, Director of Open Data Project at the Court of Cassation of France. Joana Pimiento Quintero, Director of the Digital Transformation and IT Unit at the Superior Council of Judiciary in Colombia. Mr. Stanislas Adam, Referendaire Judge at the Court of Justice of the European Union in Luxembourg. Mr. Ronald Lenz, Director of Innovation at the Hague Institute for Innovation of Law, and Mr. Karim Matemou, Project Officer at the same Hague Institute for Innovation of Law in Niger. And finally, Mrs. Smita Gupta, Curator at OpenAI Mission in India. But before heading the microphone to our first speaker, I just want to remind our audience of the following. Please mute your microphones. Add your questions to the chat. And final point, this webinar is held in both English and Spanish. So if you need translation, just click the globe on the bottom of your screen. Pratik, the floor is yours.
Thank you so much, Kamel, and welcome everyone. So we are at the end of the year, and this is the fourth webinar that we are organizing at UNESCO. And it's always a pleasure to work with our vast network of justice operators from around the world. I have to first say a few thank yous. We have excellent partners in the Superior Council of the Judiciary in Colombia, the European Judicial Training Network, and the International Association of Women Judges, with whose cooperation we are organizing this discussion today. I have two brief things to share with you from UNESCO side. First is the Global Toolkit on AI and the Rule of Law. This is a 4-part curriculum on AI, introduction to AI, use cases of AI, how is AI being used within the judiciary, but also what are the kind of legal questions and substantive issues it is raising. My colleagues will share the link to this toolkit in the chat. It's available in English, French, and Spanish, soon in Arabic and other languages. Please have a look at it. It's a useful resource. The second thing that I want to share is we've developed at UNESCO, based on a survey that we did with all of you earlier last year on the use of generative AI in courts and tribunals, we've developed some guidelines. And these are draft. We've consulted quite widely with all of you over this past year. And these are also available in the chat, and my colleagues will be sharing the link. Without further ado, I hand back to Kamel, and I hope this will be a fantastic conversation. I know so many of the speakers that we have here, and looking forward to it. Back to you, Kamel.
Thank you, Pratik. So now the floor is to Mr. Hafid Boulakras from EJTN. Hafid. Can you hear us, Hafid?
Happy
This is
you're
the
muted.
English interpreter.
Yes.
Yes, okay. Okay. It's a real pleasure to be here. I was seeing that I was asked to make this introduction, and I was impressed by all the people I know and are here around the table. So I just wanted to say hello to all the people I know, and to introduce my speech, saying that of course it is an honor to speak at today's seminar, AI in the courts. And also to speak not only as a member of the EDGTN's Digital Working Group, but also as Deputy Director of the École Nationale de la Magistrature, and to say how I'm delighted, of course, to see so many distinguished legal professionals around the table. Thank you also to UNESCO, and if it is possible, directly and personally to Mr. Pratik Sibal. I was last week in South Korea working about AI. I'm not an expert at all. I'm just a trainer, but I was there on this specific topic, and the first person I heard about was Pratik Sibal. So you are very well known all around the world, Pratik, and also in South Korea, and also when we are talking about judicial training networks. So I would like to highlight the strong collaboration between UNESCO and EGTN's Digital Working Group. I am the leader of this working group. This partnership, which began last year, has grown rapidly, very quickly, and shows how vital it is to work together across institutions to address the challenges and opportunities of digital transformation in justice. Together, we focused on the intersection of AI on the one hand and the rule of law on the other hand, with a clear commitment to safeguarding human rights. We organized a wonderful meeting and seminar in Syracuse with Pratik, but Kamel was also with us at this occasion. And one example of this collaboration is the use of what Pratik has said just right now, the UNESCO's Global Toolkit on AI. So I do exactly what he did right now. I call everyone around the table to see exactly what is this toolkit, because it is just wonderful when we are talking about AI and rule of law. This toolkit provides the judges, if I say the things right, and if it is not the case, Pratik just intervene and tell me that I'm not saying exactly what I have to say about it, but this toolkit provides judges, prosecutors, and court staff with all the knowledge that we could have when it is the moment to talk about AI, impact, responsibility, and ethical problematic when it is related to AI. EGTN at this moment has actively shared it with all the members that were there in Syracuse, but not only. We shared it also with all the members of our network. And I think that it helps the European judiciary to integrate AI into our work. So this initiative reflects clearly our shared goal of fostering a judicial system that embraces technology, because it is wonderful, but also it is necessary to protect justice and human rights. And that was the goal of this meeting in Syracuse. And I think it is the goal also of this specific toolkit. We are honored also to have, at the occasion of this meeting, of this seminar today, Mr. Stanislas Adam. He is with us today. Mr. Adam is, he will present himself, of course, but he's a referendar at the Court of Justice of the European Union. And he's professor also of European law at Ghent University. We are very honored because within the EGTN, within the European Judicial Training Network, he brings invaluable expertise to our discussion. So we are very proud to be here today with him. His experience, especially in European law, helps us to understand AI's practical role in judicial systems. Today, I think that Mr. Adam will present the AI strategy of the Court of Justice, and also he will share how the Court of Justice is using AI. His insight is invaluable, I said that already, for the global judicial community. So thank you, Stanislas, for accepting the EJTN's invitation at this occasion. And I would like to conclude saying that this webinar aims to explore how AI can improve judicial processes, making them more efficient and accessible. We will look at practical application, of course, and innovative use cases toward a vision of what is fair and more inclusive when we are talking about legal system for all. So thank you. Thank you to, I think if I read well that we are 82 around the table today. That's just wonderful. Thank you to all participants and experts for your dedication to this important topic. And thank you also for inviting EJTN and École Nationale de la Magistrature to intervene today. Many thanks, and again, Pratik, I'm very happy to know you because you are very well known all around the world. Many thanks for that.
Thank you so much, Hafid. Now the floor is to Mrs. Natalia Gaonas.
Good afternoon. Thank you, and greetings and thanks from all the participants from UNESCO who made this webinar possible, and obviously to each and every one of you who is following this call. It's very, very meaningful to have this opportunity to offer a few words of welcome from the Judiciary Superior Council in Colombia that I represent. And this is a really important webinar so that we can take a deep dive into what AI means for our judiciaries. And first, we have to recognize that ethics and human rights are key aspects of this discussion. The same is true for the alliance and the information sharing exercises that we got into as of the start of this year between Colombia and UNESCO. We need to look at how this technology can be used and what are the ethical implications. Debates like this offer us a chance to discuss what is really happening on the ground in our respective judiciaries from around the world with our specificities in each country, so that overall we're going to have different points of reference from around the world, and we can see what is being done in each other's countries. I think the expected outcome of this webinar would, and I hope I speak for everybody, is that we can get first-hand information as to the way that people are experiencing the use of AI in their different justice systems from around the world, and understand on the basis of concrete and practical examples of what is actually possible. We're also keen on hearing about how this experience and these cases are going to be able to give us feedback so that we can have all the more relevant feedback and analyses, and make sure that we can break away from what is the purely almost artificial theoretical framework and really get down to the nitty-gritty and get feedback from how AI is being used in the field. And obviously, I want to thank everyone in advance for giving us those insights into their practical cases on the ground. Now, with the Superior Council of the Judiciary in Colombia, we're using our own, we're having our own experiment, if you like, with AI through the work of Johanna Pimiento Quintera, who's Director of the Digital Transformation and IT Unit in our Superior Council. And they're hoping to come up with a clear and safe framework for the use of AI and other IT tools and what this means for ethics, and that is why we're happy to work with UNESCO on one of these, on some of these aspects. But we're also looking at building the knowledge base and capacity when it comes to the use of this kind of technology in our country. And we have a few one-off capacity building initiatives that are underway. Well, they're being developed. We hope soon to run them. And finally, we wanted to hear what everyone else is up to, see what cases you've had, how are you resolving some of the issues that come up when you use this kind of technology, and to find out where AI dovetails with the judiciary and the judicial mission. So that is why here with Johanna, we are delighted to take part into today's webinar. We look forward to hearing from all of you, and welcome once again to one and all. Thank you.
Thank you so much, Natalia, for your remarks. So now let's start exploring the practical applications of AI in various judicial systems. So now the floor is to Mrs. Vanessa Diaz-Rodriguez. Vanessa, over to you.
Hola, muy buenos días. Muchísimas gracias.
Good afternoon, and thank you very much for this introduction. And I'm delighted to be able to share with you the information that we have. I'm director of the Digital Transformation and IT Unit. I'm hoping that this will come on the screen now. So the project is called Ask Sor Juana, which is from the judge Ana Margarita Rios Farhat and her legal team. And the idea is to make sure that the information that is being made public can be understood by the general public. We know that when sentences are being drafted, we know that there are some sentences that are sensitive from a human rights perspective. We want to make sure that the information is accessible and transparent, and that is why sentences of public interest need to be made public. But at the same time, we want to respect personal privacy and data privacy, and that is why we're looking at draft sentences that are going to be discussed either in the first instance or in the lower courts. We want this to be made accessible but understandable to the general public. Now, why? Because currently, the sentence is being tested with asterisks to try and protect personal data, but we found that actually made them incomprehensible. Why? Because when you come up with information that's filled in with asterisk, 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 then you asterisk, asterisk committed an act of violence against asterisk, asterisk, and it just became unreadable for the user, and that is why we wanted to make this more understandable for users. Finally, the information came in heavy, dense paragraphs and made it very, very difficult. It wasn't at all user-friendly for members of the general public who might want to use it. And also, we've got a very legalese kind of writing, and it made it very unwieldy. And so we tried to simplify the language, streamline those paragraphs, and try to get rid of as much legal technical language as possible, so that the broader public would be able to take over.
There were several concerns about Sor Juana. People were drafting public versions of the text using asterisks and trying to anonymize information using neutral terms, for example. Therefore, Sor Juana didn't have access to files nor to the original versions, the official versions of texts. What's the error rate of Sor Juana in terms of privacy protection? Well, once the public version can be found according to internal regulations, we upload this and we test it. And once we think it's ready, we open access so that people involved in projects can, in the project rather, can look further into the legal side of things. And so there's a double check on privacy in that sense, to make sure that there's no access to files or personal data through Sor Juana. And if there is any error in terms of so-called hallucinations of the system, then we ask the project team to always carry out a process to analyze this using screen grabs, for example. We only deal with one case at a time, and before releasing files to the public, we go through this testing process, and once they're released, then we continue to test Sor Juana. Who are our users then for Sor Juana? Well, we don't actually gather any personal data from our users. Sor Juana functions with open access software. What we do is we look at each case individually. We identify the kind of questions that come up, and that allows us to analyze the questions asked and answered by Sor Juana. So that's all about Sor Juana. I'll leave the website here. Anyone can log on and ask Sor Juana a question, or you can use the QR code. So it's been a pleasure to talk about Sor Juana, and we'll see you on Sor Juana soon. Thank you.
Thank you so much, Vanessa, for this. Yes, please go ahead.
Vale.
Okay, thank you, Vanessa, for this very fascinating presentation. Now we are moving to our next speaker, who is Mr. Edouard Rothier, Director of the Open Data Project at the Cour de Cassation of France. Edouard, over to you.
Hello to everyone. Many thanks for the invitation. It's really an honor for me to speak before you. So I am happy to present on the use of AI by the French Court of Cassation, which is in France the highest court regarding civil and criminal cases. So, sorry. So now we have already a few years of experience using AI at the Court of Cassation. And the specificity is that we rely only on an in-house team hosted at the court. And so we have a data science team which is hosted by the Service of Documentation and Research of the Court of Cassation. And as regards human resources, we have two in-house data scientists, which are led by a magistrate of the courts, who work also with the judges of the court and legal assistants. We have also internal computational means, so we have bought and installed some powerful GPUs on the servers of the court. And as regards data, we have a very comprehensive legal database administrated by the court. And these legal databases cover, of course, all the judicial activity of the Cour de Cassation, but also decisions rendered by all courts in France. So, in fact, we have all the ingredients needed to have a use of data, because we have the human resources, data scientists, and magistrates. We have the computational means, and we also have relevant data. So I will present first two AI tools that are already deployed and that are in production at the French Court of Cassation. So the first project has been a project on pseudonymization of court decision because the French Cour de Cassation is responsible in France for the publication, for the online publication of all decisions that are rendered publicly by courts. So not only the decision of the Court of Cassation, but also all civil and criminal courts. So in order to address the issue of pseudonymization, we have trained a machine learning algorithm in order to recognize identifying features such as names and addresses in court decisions. And then there is a human supervision, which is based on a risk assessment. So we have a very powerful tool, very powerful pseudonymization tool, which helps us publish a decision while removing the main identifying features. And this project is already deployed since 5 years at the court. Based on this first achievement, we have quite quickly deployed another AI tool, which is a tool, which helps the magistrates of the service of documentation to direct the different requests to the competent chamber of the Cour de Cassation. So in fact, there are 6 chambers at the Cour de Cassation. There is 1 criminal chamber and 5 civil chambers, and these different 5 civil chambers deal with different legal matters. And the requests have to be directed to one, the civil requests have to be directed to one of those 5 civil chambers. So also based on machine learning algorithms, which has been trained on previous cases, we have now also a very efficient tool which makes a proposition of direction to new requests, and it has really been a huge gain of time and efficiency for the service of documentation. So that was the 2 projects already deployed. We have also an ongoing research and development on another project. The goal of this specific project is to assist the Cour de Cassation in identifying inconsistencies in jurisprudence, because the main role of the Cour de Cassation is to ensure that there is consistent interpretation of law and consistent application of law in France. It is very important for the court to identify where and when there are some inconsistencies between different chambers of the court and between lower courts. So the method for this project is to identify divergent answers to the same legal question. So for this goal, we do not have yet results that could be sufficient results to deploy this tool to assist us in identifying inconsistencies, but we have already good results with intermediary steps and use cases that have been developed for this project. So the first step is to identify similar legal questions, and we have a tool that gives very good results as identifying similar legal questions among different decisions. And we have also a tool which is quite efficient to summarize court decisions and to label court decisions. So this is still ongoing research. Now we are also reflecting on new use cases and new projects for the Court of Cassation. And for this purpose, there is an ongoing working group on the use of AI by the Cour de Cassation. This working group is composed with representatives of all the chambers of the Cour de Cassation, and the goals are to identify and to assess new use cases to be developed. We have already identified 3 different types of usage of AI. The first would be to enhance legal research based on legal databases administrated by the Cour de Cassation. The second type would be the assistance in analyzing the parties' submission, for example, to extract some relevant data, to identify that there is a new legal question, or to help in the direction and triage of the request. And the third type is to assist the judges in drafting decisions. Of course, it would be the most problematic usage. And so all these use cases will be assessed by the working group. And we have also identified criteria of assessment of those AI projects. Of course, those projects should be compliant with the regulatory framework applicable in France. Mainly, that would be the General Data Protection Regulation and the Artificial Intelligence Act under European Union law. And then the two main issues would be to respect fundamental rights and ethics, so to have a fundamental rights and ethical assessment, and also to assess technical feasibility and cost. Thank you.
Thank you, Edouard, for your insightful presentation and very clear presentation. Now let's move on to Mrs. Joana Pimiento Quintero, Director of the Digital Transformation and IT Unit at the Superior Council of the Judiciary in Colombia. Joana, over to you.
Bueno, muy buenos días, muchas gracias.
Good afternoon, and thank you very much for kindly inviting me to participate in this extremely important webinar today. And thanks for the chance to speak about Colombia's experience. I'm going to share my screen with you here. Just a second, please. Can you see it? Yes, perfect. In Colombia, we are working on linking artificial intelligence into our judicial system based on a strategy which firstly looks at how we work. There was a study in which over 3,000 judicial personnel participated, and we started to get an overall picture of how AI was being used. In this process, we had many public servants who participated, and over 30% of public servants were using AI tools, which allowed them to carry out judicial processes. So who are using these platforms? Well, all kinds of people, mainly judges and secretaries, who are the main people who process information to be able to carry out a judicial process. Those are the main people using the tools. What else did we find? Well, the uses made of AI have much more to do with general information rather than specialized legal information. People were looking for summaries of texts because there's a huge volume of documents that people have to process and use, and people wanted summaries and simplifications. But they're also using these tools to be able to make corrections and to edit texts. So people are using publicly available information processing services and data analysis services. They're particularly making a lot of use of ChatGPT. In the study, we found about 108 AI projects that were being carried out throughout the judiciary. A very important issue is audio transcription, and technology has been implemented to allow people to do this automatically. But there are projects that are looking at this further. There are also projects going on among magistrates and lawyers who are involved in the process. So how do we ensure a safe and responsible implementation of AI? Well, we're coming up with an innovation strategy that we call Justice Lab, and this strategy looks at three main issues: knowledge sharing and skills. We look at the conditions of texts, and we look at people's skills and abilities. We are trying to train people to use this kind of tool responsibly and safely. We also use capacity building processes, podcasts, for example, to raise awareness of AI issues, responsible use, etc. We also have explored different tools and different cases of use which are acceptable and which aren't. And we propose that these solutions are intensified. There will certainly be several conclusions that we'll come to in terms of AI, but we have to come up with solutions. And we're also working on another front, which we work on closely with UNESCO, and that's defining a responsible use framework. And this is interdisciplinary and interinstitutional work to be able to define the concerns and the opportunities that there are in this area, so that we can ensure the responsible use of these instruments. We have been building a community of work in which many people are involved, particularly judges and magistrates, and people in different jurisdictions are participating in the projects. I wanted to try to share these videos with you. If you want, you can have a look to see how people are participating in the project.
No.
The speaker asks, can it be heard? So I'm being told that we can't hear this, so I'm just going to explain that this is a judge from Barranquilla, and he was hoping to speed up some of the transcription activities and speed up some of the paperwork relating to hearings, and so he was describing that experience. And the other one is from a judge from Medellin, from the Civil Court of Medellin, which is a region here and a major city here in Colombia. And here they were looking at the use of this technology when it comes to decision making. And the conclusion that they reached was that even though we have all of these tools at our disposal, we cannot at this stage use them indiscriminately, and in no way can they be considered a replacement for a human being when it comes to decision-making processes. So those are some of the a little bit of feedback and experience from some of the working communities that we are dealing with, and their feedback is precious for us to incorporate better working methods into our processes. And here we have Diana Sanchez Serna, who's from the Secretariat General of the Council of State, talking about how they were using this technology for drafting, for research, for going through transcripts, and they found that it did actually save a lot of time. So that gives you a little overview of the work that we're doing in Colombia and how we can incorporate AI into our judicial system, and doing it with a great deal of responsibility and transparency. Thank you.
Thank you so much, Joanna, for your insightful presentation. Now let's move back to Europe, and now the floor is to Stanislas Adam, who is a judge at the Court of Justice of the European Union in Luxembourg. Stanislas, over to you.
Thank you very much. I'm just going to share the screen first. I must only specify that that I'm not a judge. I'm a referendar of the cabinet of the president of the court. Can you visualize the presentation?
Yes, we can.
Okay. Okay, so thank you very much indeed for the invitation. Thanks for the kind words that I have heard so far. I must say I have already learned a lot today. I would like to thank the previous participants. I gathered sources of information which will definitely be useful for our future orientations and practices. What I wish to do is briefly shed light on the AI strategy of the Court of Justice, first emphasizing that it forms part of the CJEU's digital transformation, which started already long ago. Then I will delve into more detail in the strategy itself and the guidelines that have been adopted very recently, implementing them. And I would like also to say a few words at the end on the impacts or the likely impact of the AI Act on the CJEU and the ambivalent relationship which the court has with that act, both being subject to that act and the official or ultimate interpreter of that act as the EU court. So first, the digital transformation of the Court of Justice. We have, as some of you know, started that digitalization with the e-Curia application concerning submissions made to the court. All of that happens now, or a vast majority of it happens electronically. We also have digital files helping us carrying out our tasks, and in the near future, hopefully, the SIGA new IT environment of the court, which will be largely based also on artificial intelligence. We also have created an innovation lab in 2019 at the level of the Direction des Technologies de l'Information, which is a member of the AI Network Plus, gathering information on useful tools for useful AI tools, AI algorithms for judicial functions. And last but not least, of course, we now have an official and public artificial intelligence strategy disclosing, revealing AI management, the conception by the court of its AI management for the years to come. I already insist now that this is a work in progress. We are still at a very early stage of the development of AI at the Court of Justice, and step by step seek to identify how we can make the best use of it. Which is a perfect transition indeed to the AI strategy itself, published with the annual report in 2023, prior to the adoption of the AI Act itself. And as I will try to highlight at the end, we can safely say, I think, that the court has anticipated most of the requirements of that AI Act, although some question marks remain after the adoption and entry into force of that Act. And important preliminary point, it covers all activities of the court, not only the purely judicial pillar of the Court of Justice, but also the administrative pillar, which, as you probably know or will easily understand, is quantitatively and qualitatively extremely important within the multilingual environments featuring the Court of Justice, with 24 official languages, only one working language. All that multilingual language environment creates constraints that make it particularly important also to think about how we can make best use of AI for the purposes of interpretation or translation. That strategy builds first upon the acknowledgement that AI can certainly have advantages for justice. Those advantages will not surprise you. They relate to efficiency, thanks to quicker and maybe even more focused research, context-sensitive search engines, the use of speech-to-text algorithms, allowing the generation of very quickly generation of hearing transcripts, the quality and coherence of judicial decisions. My colleague from the Cour de Cassation in France has already mentioned that earlier on, and also facilitating access to justice and transparency of EU justice. We operate also in a specific context here as an international court. I should say a supranational court, but still not a court of the member states, and which may be perceived, even including by lawyers, as a relatively distant judicial organization. For example, AI could help us in the future closing that gap or reducing that gap with litigants in the member states or lawyers in the member states, even national courts, by creating or by using virtual assistants, enhancing knowledge about EU case law or EU procedures. At the same time, AI obviously comes with risks. Most important risks relate to unintentional biases, especially the risk of discrimination as a result of or a lack of control on, for example, the way in which an algorithm will distinguish between relevant and irrelevant information. Second risk, the disclosure of sensitive data, generation of false, inaccurate, or irrelevant information. The strategy acknowledges in particular the risk of hallucination, that is the risk of creating seemingly correct information, whereas in fact it is not correct. The lack of human critical thinking, and integrity, of course, of our digital environment. You should know that we are subject every day to, I have heard, close to 1,000 cyber attacks a day. So, of course, with the use of AI, that risk might even be higher. There was this a clear need for a governance model concerning AI at the Court of Justice, which is the reason why the strategy firsthand creates an AI management board within the court. A key organization of that organization feature of that board is its inclusiveness. It reflects in its composition all interested stakeholders within the court. So not just members of the courts themselves, judges, advocates general, and not just advocates general and judges of the two courts, the General Court of the EU and the Court of Justice, but also people working representing the services, translation services, the registrar, and so on and so forth. Its task is to elaborate guidelines following a risk-based approach. So what the AI Management Board received as a mandate was to distinguish, in essence, 3 types of situations. The red lines, that is, situations or instances, processes which belong to the core judicial missions and functions, and for which there should therefore be no use of AI at all. The identification of areas of special attention, that is, areas which may raise specific risks related to the use of AI, and which therefore call for careful monitoring, certain mitigation strategies, for example, legal research. And then areas of low risk, where we can safely build upon every member of court staff conscious and enlightened application of AI tools to avoid risks. So not calling for specific mitigation strategies. And the second important aspect, as I said, is indeed the innovation lab created within DTI, called upon to collect relevant information on the market on AI algorithms that could be, or AI practices that could be useful for the court in the long term. Importantly, the CJEU strategy formulates 6 principles that will guide us in the future at all levels of the organization and decision making. They were inspired in part by the 2016 CEPEJ ethical guidelines on the use of AI for judicial functions. They speak for themselves. I only mention them here briefly. There is, of course, fairness, impartiality, and non-discrimination relating to the risk of bias. Transparency. It should always be possible to understand how an algorithm has produced a given result. Traceability, allowing for audit and possibly also selected verification of what's been produced and done by an algorithm. Traceability, privacy and data protection, since most AI tools are based on open data sources. Privacy and data protection, human oversight, and continuous improvement. This is part of a broader effort, that strategy. It is a work in progress, and clearly we will have to keep training our staff and keep thinking about certifying certain AI tools. We have so far been quite reluctant officially certifying, let's say, AI tools. I must say that it seems to me that the Court of Cassation, for example, is already a step further compared to what we have here at the Court of Justice, which may partly be related also to the supranational nature of our work and the great diversity of legal traditions that we are coping with here within the Court of Justice. Those principles were implemented very recently by guidelines adopted by that AI management board, for example, emphasizing the duty of every staff member to critically assess any response produced by a generative AI tool, and ruling out the use of AI tools for any sensitive tasks, for example, the drafting of judgments. The AI Act, now a few words. There is, as I said, an ambivalent relationship between the court and the AI Act, since the Court of Justice is clearly subject to the AI Act. We will have to see if it is a provider or deployer of AI system under the Act, but it will, as I said, also be the ultimate interpreter of the AI Act as a piece of EU legislation. The AI Act contains horizontal prohibitions, which are reflected in the general prohibitions, which are reflected in the strategy. For example, avoidance, absolute prohibition of subliminal techniques or purposefully manipulative or deceptive techniques. But there are also far-reaching precautionary principles for high-risk activities, among which judicial functions. I refer here to Article 6 of the AI Act. Those precautionary principles cover, for example, the requirements to establish risk management system, the validation of AI systems following quality testing, and record keeping, which is key for auditing purpose and which echoes the traceability principle in our AI strategy. So all that relates to the qualification of judicial functions as high risk. Of course, the AI Act also acknowledges that not everything should be regarded as high risk. I refer here to recital 61 of the AI Act, shedding light on the fact that those precautionary principles should not extend So those specific obligations do not extend to AI systems intended for purely ancillary administrative activities that do not affect the actual administration of justice in individual cases. I have to say the wording here is quite strict. We will have to see, and I have to be very careful here for the reason that I explained. It is possible, it is even likely that the court will have to interpret this provision in the future, but it sounds quite restrictive. So I emphasize on the wording purely ancillary administrative activities, covering probably anonymization or pseudonymization or purely administrative tasks. How could we interpret it? What is upstream and downstream of the judicial decision-making process itself is probably not covered or probably can escape qualification as high risk. I'm thinking of translation, for example, here. Maybe also case allocation in the future. I again refer to what my colleague from the Cour de Cassation has said. At this stage, we do not use AI for allocating cases, but there are still question marks as to the exact delineation of what is covered and not. So what I can say as a conclusion, the court has probably anticipated most of those requirements, but there are numerous questions open. For example, if we at some point certify an AI tool based on the fact that the AI tool is itself based on the self-training, it might be that the AI tool will change itself within the code its original purpose, which would convert the court or change the court as a simple provider, as a simple deployer, into a provider of AI tool, which would trigger certain obligations, like, for example, internal conformity assessment and also external auditing. In particular, for example, by the Commission, which will or which might raise issues of judicial independence. All that calls for modesty, I think, by all of us, and courage. We might have to change our practices. We might have to train more, to adjust and to adapt and to be more efficient, and to thus create more confidence and trust of litigants in our justice systems. But all that should not lose us sight from our key role in upholding the rule of law and upholding judicial independence and the proper administration of justice in our justice systems. And in this respect, I have to say, novel issues are expected before the Court of Justice. You know that our court has been quite proactive in guaranteeing rule of law and judicial independence in the recent past. I'm pretty sure that an improper use of AI might put judicial independence in the member states at risk in the future. And I make no risky bets if I say that certain questions might emerge in the future as to how EU treaties and fundamental values whereupon the EU is based could be endangered by improper use of AI tools. That is yet another aspect more related to the substantive role of the Court of Justice, the constitutional law, Court of the Union, that we can expect for the future. Thank you for your attention.
Thank you so much, Stanislas, for this very detailed presentation and the questions you are raising. Before moving to the next speakers, I just want to remind the audience that you can feel free to ask your questions in the chat. So we'll have a fruitful conversation after the end of the presentations. So now let's move to our two next speakers, Mr. Ronald Lenz, who is the Director of Innovation at the Hague Institute for Innovation of Law, and Mr. Karim Matemou, who is a Project Officer at the Hague Institute. Mr. Lenz, Mr. Matemou, over to you.
Thanks so much for the invitation. I think having these open platforms for knowledge exchange around AI for justice is critically important, especially now in the early days of AI for justice. So my name is Ronald Lenz. I work for the Hague Institute for Innovation of Law. And the way we work is really people-centered. So people-centered justice programming, redesigning justice systems, much more around people's needs, their experience, and the outcomes they want. So we're very data-driven, evidence-based, and innovation-focused. So if you look at this picture, it illustrates the justice gap. We do a lot of data research, massive surveys, which we call justice needs and satisfaction surveys. And in the many countries in which we've done them, we often see the same. We see that about a maximum of 10% of people with justice issues go to lawyers and courts. There's a lot of self-help. Most of it is fixed at community level, and still 55% of the people with legal issues, these issues are not resolved. So when we think about AI, let's go to this. We don't only think about the importance of AI for more effective courts or even more efficient practices at law firms, but we especially look at this orange part where we see the big, the big opportunity space for helping as many people as possible with new innovative justice services. So that's why we really think that the power of community justice, as it already works with customary law, could be even more powerful through the support of technology and AI. So when you think about these things, think about, it would be easy to know your rights, but in a local language, or you could easily navigate your own personal situation and get referred to the right legal support or assistance, or customary law is supported by AI to do dispute resolution a lot better. And you can prevent also a lot of issues if you have better document and contract automation. Don't get me wrong, this is not just about technological advances at all. I mean, Stanislas said it really well and presented the importance of having the right enabling environment in place. So the right regulatory frameworks, the governance models to make all of these things possible. And look, this picture is a bridge and all of it is connected. So it's not community justice in isolation, but connected to the formal justice sector. And I think that is also a huge opportunity. So before I hand it over to my colleague, I just want to leave you with the idea that wouldn't it be great if maybe 5 years from now there would be an open justice platform, a community justice AI starter kit that many, that I would say most CSOs or governments could implement at a community level that have these kinds of tools. And of course, with the guidelines around the right enabling environment. So we do a lot of innovation programs, Justice Innovation Labs. I've heard the word innovation lab already quite a lot. And we recently did one in Niger, where we really zoomed in on how to best manage land and resource disputes. One of the things that came out is a voice-assisted AI-powered legal assistant, but Kareem can tell this a whole lot better than I can. So over to you, Kareem.
Thank you, Ronald. Hi, everybody. So based on what Ronald said, we are implementing a project here in Niger. The project is part of Innovation Lab, and the project uses AI to overcome barriers of accessibility, of level of education and funding. So at this stage, the project is not based on direct service offered by justice system, but on access to justice more generally. It's understanding the way in which certain justice issues can be managed. Based on the result of GNS, we have identified the most current problem, which is crime and offense, and which come first. And secondly, we have land dispute. So in collaboration with our strategic partner here in Niger, which is the Ministry of Justice, we have chosen to focus on land issues. This choice was supported by the fact that we advocate person-centered justice, as Ronald say, and this enabled us to highlight ADR. So we set up an expert committee which was made up from formal justice actors, CSO, academics, and traditional rulers to carry out a more in-depth analysis of the problem and the construction of a solution for land dispute in Niger. So after analyzing the legal system and a number of different justice journey, it emerged that the customary justice was the first and principal mechanism of handling land dispute in Niger. So the Niger justice system integrate and recognize traditional justice by granting it conciliatory power. So that's the base of the solution we developed. And the question was, so why does the customary authorities were not fully taking charge of land conflict in Niger? And the main reason was the lack of knowledge of text and procedure by customary authorities and litigant. So to remind that on an online digital platform was developed, but a number of issues was raised, namely the number of users with a connectable telephone, the poor internet coverage, and the low literacy rate. So in response to these challenges, we have integrated a voice assistant in the solution based on on artificial intelligence to answer direct questions about problems. A database will be fed with text and regulation in force in Niger. And this will enable us to meet the significant financial requirement for training and popularizing the texts, and to reach a large number of traditional leaders. So the focus on traditional leaders is, we hope, the starting point of the project. If the results are convincing, the capacity to develop the solution is important, as translation into local language will enable us to reach a greater number of people, and the area or issues covered by could be expanded to a more large type of problem or population. So that's the project we are implementing in Niger, and we hope it will be the beginning of the use of intelligence artificial to help people which are not sufficient, which could not read, but will have access to a lot of important information about their rights and the different mechanisms of justice in Niger. Thank you.
Thank you, Karim. Thank you, Ronald, for this very fascinating project and presentation, and wish you all the best to develop this project in the coming months and years. And now it's time to move on to our last speaker, and I just want to thank her for her patience. Our last speaker is Mrs. Smita Gupta, a curator at OpenAI Mission in India. Smita, over to you.
Hi, can you see me and see my screen, hear me? Okay.
Yes.
Fantastic. Thank you. Hi, everyone. I have the unenviable job of going last, but I hope to sort of end it on a high note by sharing 3 extremely exciting ideas with you. And kudos to my co-panelists for sharing some brilliant initiatives in their own countries, and just so much to learn here. So very excited to be part of this panel. Thank you so much for having me. My name is Smita Gupta. I'm a lawyer and a legal technologist based in India. I've been working on uses of, how can we leverage artificial intelligence for increasing access to justice for the last almost 4 years now. And it's so almost serendipitous that we are talking today, because just yesterday, this is the news that we all woke up to in India. It was the launch of India's first 24/7 online court in one of the districts in a southern state in India. Why this is, I mean, in and of itself, of course, it's extremely exciting and it's a huge milestone for the country. But I want to share a little bit more context so it becomes, more digestible about why this is actually exciting. So India is the world's largest population, right? With 1.4 billion people, that should be 1.4. We have 22 scheduled official languages, but more than 100 languages which are spoken by more than 10,000 people, making the Indian subcontinent with 122 major languages, where currently the cases which are pending in court go up to more than 3 years. Sometimes there are cases even from as far as back as 20-25 years. Even as that is the case with this huge amount of pendency of millions of cases, 90% of people don't actually end up going to court, meaning that they're not able to access legal rights, their legal right to representation. In our constitution, we have been granted the constitutional right to free legal aid. However, only 10% of the population in India is able to access this legal aid. And to sort of make the entire thing worse, the economic condition is such that the bottom 50% of the population has only 1% income of the top 10%, making the scenario that those who actually want to be able to access justice are not even able to afford it, to reach it, and it's entirely inaccessible. So what are we doing about this, right? How are we solving these age-old problems of the justice system, which are unique to India, but you'll see in your country a lot of the problems also represented here. I come from an organization called Agami. Agami means what is about to come. It means the future. And the way we work is we harness the power of new ideas and new change makers to exponentially improve our systems of law and justice. We've been doing this for the last 7 years by acting as ecosystem enablers to bring about more innovation in this space. And, all the work we do is always in a collaborative manner. So Open Nyay, which is one of our missions. So the pun we've made here is Nyay means justice in Hindi. So we sort of spell it as NYAI because we're saying we're going to leverage artificial intelligence to create open source softwares, open source data sets to catalyze the real potential of AI-powered solutions to access justice. And we do this in a collaborative manner. We started with 5 organizations, with Agami being the anchor partner, and today we are 50-60 organizations strong. Having said that, with this sort of small context, I want to again go back to the very exciting news that I started with and show you a small 2.5-3 minute clip to tell you a little bit about how this project came about. And just as a little bit of context, this is a pilot court only dealing with one kind of case, which is check bounce cases, as you can see here. So when you go to the bank to get a check, submit to the bank to get the money disbursed in your account, and the check bounces, you're not able to get the money because the person does not actually have that amount of money that he or she has promised you through that check. That currently is both a civil as well as a criminal wrong in India today. So because of its dual nature of illegality, there is a huge pendency of check bounce cases, also known as Section 138 cases in India's courts today. Up to 10% of all criminal cases today in India are check bounce cases. In that light, I'll just like to show this quick video, and I hope you're able to hear it.
ഞങ്ങൾ കൊല്ലത്തെ അഭിഭാഷകരോട് ചോദിച്ചു, നിലവിലുള്ള കോടതി നടപടികളിലെ എന്ത് മാറ്റങ്ങൾ അവരുടെ ജീവിതം മികച്ചതാക്കുമെന്ന്.
As far as Kollam is concerned, the family court is far away from here. After appearing this court, I won't be able to reach that court. So it's easy for me to appear through online.
കേസ് ഫയലിംഗിൽ ഒരു ഡിഫക്റ്റ് ഉണ്ടായാലും ആ ഡിഫക്റ്റ് ക്യൂർ ചെയ്യാനായിട്ടുള്ള എളുപ്പ വഴികൾ ഉണ്ടാവണം. അതിലൊന്ന് പ്രധാനമായിട്ടും പറയുന്നത് ഒരു ചെറിയ ഡിഫക്റ്റ് ഉണ്ടെങ്കിൽ ആ ഡിഫക്റ്റ് മാത്രം ക്ലിയർ ചെയ്യാനുള്ള ഒരു സംവിധാനം ഉണ്ടാകും.
ഒരു ഡ്രാഫ്റ്റിംഗ് ചെയ്ത് നമ്മൾ സബ്മിറ്റ് ചെയ്യുന്ന സമയത്ത് അതിൽ എന്തെങ്കിലും ഒരു ചെറിയ മിസ്റ്റേക്സ് ഒബ്വിയസ്ലി ഉണ്ടാവും. ജൂനിയർ ലോയർ ആകുമ്പോഴത്തേക്ക് നമുക്കൊരു പ്രോംപ്റ്റ് ഉണ്ടെങ്കിൽ ആ ഒരു ഗൈഡൻസ് ഡ്രാഫ്റ്റിംഗിൽ നമുക്ക് തരാനും ഈ ഫയലിംഗ് കൊണ്ട് സാധിക്കുന്നുണ്ട്.
We want to make your wishes a reality through on courts. We are first starting with the check bouncing cases in Kollam. We have addressed many of the challenges faced by the lawyer community and we are trying to solve the same.
24/7 on courts, accessible anywhere, anytime. The first digital courts for 138 Negotiable Instruments Act courts launched at Kollam.
സ്വന്തം ഓഫീസിലോ വീട്ടിലോ ഇരുന്നു കൊണ്ട് തൻ്റെ കേസുകളെ സംബന്ധിച്ച് വിവരങ്ങൾ ആരായാനും മനസ്സിലാക്കാനും കഴിയുക എന്നത് ഇന്ന് അഭിഭാഷക സമൂഹം നേടിയിട്ടുള്ള വിപ്ലവാത്മകമായിട്ടുള്ളൊരു നേട്ടമായിട്ടാണ് ഞാൻ കാണുന്നത്.
ഒരു അഡ്വക്കേറ്റ് അയാളുടെ ഓഫീസിൽ ഇരുന്നു കൊണ്ട് അദ്ദേഹത്തിൻ്റെ സൗകര്യം അനുസരിച്ച് ഒരുപാട് കേസുകളിൽ അറ്റൻഡ് ചെയ്യാൻ പറ്റും എന്നുള്ളതും ആയതിനുപരി ഒരു ദിവസത്തെ വർക്ക് ലോഡ് പ്രീ പ്ലാൻ ചെയ്ത് ഷെഡ്യൂൾ ചെയ്യാനും പറ്റുമെന്നുള്ളതാണ് ഈ കോർട്ട് സമ്പ്രദായത്തിൻ്റെ ഏറ്റവും വലിയ ഗുണമായി ഞാൻ കരുതുന്നു.
24/7 ഓൺ കോടതികൾ വഴി നിങ്ങൾക്ക് അപേക്ഷകൾക്ക് മറുപടി അയയ്ക്കുക, ഉയർന്ന നിലവാരമുള്ള VC വഴി ഹിയറിംഗിൽ പങ്കെടുക്കുക, സ്വന്തം ഓഫീസിൽ തന്നെ ഇരുന്ന് സമൻസ് സ്റ്റാറ്റസ് ട്രാക്ക് ചെയ്യുക തുടങ്ങിയ പ്രവർത്തനങ്ങൾ ചെയ്യാൻ കഴിയും. തെറ്റുകളുള്ള ഫയലിങ്ങുകളിൽ മുഴുവൻ ഫയലും വീണ്ടും സമർപ്പിക്കാതെ തെറ്റുള്ള ഭാഗം മാത്രം മാറ്റം വരുത്താനാകും. ഓരോ കേസിലും ചെയ്യേണ്ട ജോലികൾ വളരെ എളുപ്പത്തിൽ ട്രാക്ക് ചെയ്യാൻ കഴിയും. തെറ്റുകൾ കുറയ്ക്കുന്നതിനായി സഹായവും മാർഗനിർദ്ദേശവും ലഭ്യമാണ്. കൂടാതെ അപേക്ഷയ്ക്കായി അനുയോജ്യമായ ടെംപ്ലേറ്റുകൾ ഉപയോഗിക്കാനും സൗകര്യമുണ്ടായിരിക്കും. സ്മാർട്ട് കാലണ്ടറിൻ്റെ സഹായത്തോടെ കേസുകൾ കൂടുതൽ മികച്ച രീതിയിൽ ആസൂത്രണം ചെയ്യാനും ദൈനംദിന പ്രവർത്തികൾ മുൻകൂട്ടി ആസൂത്രണം ചെയ്യാനും കഴിയും.
The Kollam Bar Association is very proud to be a part and parcel and instrumental for the establishment of the new digital court. It will be a new advantage for the whole entire community, for the legal fraternity, for the speedy dispensation of justice.
അഭിഭാഷകർക്കും കൂടാതെ കോടതിയെ സമീപിക്കുന്ന ആർക്കും ഒരു മാതൃകയായിട്ട് കൊല്ലത്തെ ഓൺ കോർട്സ് മാറുകയാണ്. ബാറും ബെഞ്ചും എല്ലാം ഒന്നിച്ച് നമുക്ക് ഈ 24/7 ഓൺ കോർട്സ് ഒരു മികവുറ്റ സംരംഭമായി മാറ്റണം.
So you see, it ends with a very provocative idea of quotes that come to you. And, almost a rephrasing of justice as a service, justice being a dispensable service that you have a right to. This is the first exciting idea that I wanted to share with you. How can we redesign an entire, type of case to go from producing physical evidence without any proactive support for litigants, with an entire online filing of scanned documents, all of the scrutiny and the physical admissions, all of that happening physically in courts, the summons being presented primarily by the police physically, and all of the bail hearings also happening in person with synchronous hearings. How can we change this old idea of what used to happen into a new one, where you're getting an alert with verifiable digital evidence? You're able to appear in court in an online manner using online dispute resolution methods. All of these systems are natively digital. AI cannot exist on top of a non-digital infrastructure. It needs to exist on a natively digital infrastructure for us to be able to leverage it in the most efficient way possible. Can there be asynchronous admission and asynchronous and virtual proceedings so that lawyers can appear in court at different times? Litigants and citizens are able to track the status of their case in real time, and judges are able to generate their dictation and their orders and their judgments just by dictating it with a live transcription happening. So this is sort of the reframing of from the old to the new that we're looking at. This is one such initiative that is happening in India. There are plenty of others, but in interest of time, I'll skip through this, but just to broadly cover some of the ideas, there are transcription services being adopted by real-time transcription of court hearings, conversational solutions allowing for quick access to critical information and services in your Indian, one of the 22 or 122 languages. This is a Ministry of Electronics initiative in India, which is looking to create an entirely native language model for translation, transcription, speech-to-text translation of all Indian languages. Apart from that, so this is one such initiative which we have been championing at OpenAI and at Agami, which leverages generative AI to power, conversational solutions, much like what Hill just showed has been deployed in Niger. It's a very similar system where you are able to, talk in your own language through voice. And I saw somebody ask in the question box, how do we deal with hallucinations? So retrieval augmented generation, which is also what Hill was showing, is actually a great method of being able to reduce hallucinations because you're restricting the knowledge boundary of the conversation to only the data that you have provided it and not the entirety of the internet. What is amazing is that this effort has been, all of this has happened with the community in the last 2 years with Microsoft, Agami, a lot of academic institutions, research centers and universities, a lot of philanthropic funding coming in, and a lot of other tech experts who have given a lot of their pro bono time to make this happen. That goes down really to a huge design principle that we have of how you need to build with the community. But what are we really building for? So which comes to my second exciting idea for you today, which is if you're looking at everything that AI can solve for you, right? Can we divide that into, and this is not an exhaustive list, but basically, how can you help citizens with increasing their legal awareness, helping them with pre-litigation guidance, providing online dispute resolution mechanisms with legal services? How can you help lawyers and paralegal volunteers with research and drafting? And then how can you help judicial systems with filing, scheduling, providing decision support as a supplementary effort, as well as with drafting? So looking at this, many of my other co-panelists have already spoken to some of these use cases, but to sort of summarize it, can you create structured data out of unstructured data? Can you identify the different entities that exist within a judgment to say Article 32 is the name of the provision, writ petition criminal number 270 of 1988 is the case number, and you get all of this metadata and you can use that to come up with extremely rich insights and analyses. So using text summarization, data extraction, you're able to provide do a lot of classification and routing to provide access to information and services. And this was the second exciting idea, that there is a plethora of work that can be done if you're able to leverage the rich amount of data that is structured as well as unstructured data that is present in the justice system. And the third exciting idea is, even as we are applying AI to increase access to justice, what are some of the design principles that we must keep in mind when building these solutions? Should these solutions be user-centric? Can they be universal, and can they be unified? And I'm so glad that Ronald went right before me, because he was talking about community-centered justice and people-centered justice, and really, what does that mean when you start actually building solutions? And actually, very happy to also share right now that we'll be collaborating with Hill to come up to make this kind of a user-centric justice a reality. And the picture he painted about in the next 5 years or 2 years or 1 year having an open justice platform. What can that platform really look like? So can we go from an institution-centric dispute resolution system where everything is built for lawyers and police and tribunals and courts? Can we go from an institution-centric dispute resolution system towards a user-centric system, where you're putting the citizen, the litigant, at the center of everything that you're building? And what can we, possibly build? What does this architecture of a people-centric, community-centric judiciary or a judicial system look like? This is sort of a big idea that we have of creating a digital public infrastructure for the judiciary. A digital public infrastructure, or DPI, essentially means a unified interoperable layer of fundamental building blocks on which you can create multiple services which can come in handy for judges, for advocates, for litigants, for the registries. You can have a user-facing application. It can be a web portal, a mobile app, a chatbot on which you're able to access different kinds of modules or different kinds of, let's say, platforms on which you're able to access justice, like the high courts and the district courts and the mediation channels, the negotiation channels, the online dispute resolution platforms. And on these kind of user-facing applications, you're able to access through open source, APIs, which are application programming interfaces. You're able to speak with ecosystem APIs, which allow for discovering verified lawyers, which allow for accessing services like authenticating documentation, notarizing documentation, communications and alert systems for sending notices and applications and summons. You have digital credentializing services for evidence in criminal cases, and so on and so forth. On some of these kind of services, what is at the bottom, which is enabling all of this, is really a master protocol list of registries of transactions, of lawyers, of case types, of laws, of previous judgments, and so on and so forth. And these cannot exist without some amount of standardization and specifications when it comes to looking at what does, there may be a distinction between how a unit of land is identified in one state versus another state. So how can you, and there can be multiple variations of how a unit of land is referred to in the local context. So how do you standardize some of these definitions? And this is a very small example, of course, but if you're able to standardize some of these things and create specifications and master data sets, then you're allowing for an interoperable ecosystem of multiple courts, multiple stakeholders like judges, advocates, and litigants, and court staff to be able to access real-time asynchronous information of judicial services. Thank you.
Thank you so much, Smita, for your very exciting presentation. So now let's start a Q&A session. So looking at the time, we have, as you know, time constraints. So I just would like to invite, as a matter of priority, our speakers to either react or ask a question if they have some questions. If not, we will read some questions from our audience, which has been very active, and I thank our audience for their participation, their active participation on the chat. So if our speakers have a question and they want to react to one presentation, we can do that very quickly. Okay, so let me select a few questions from the chat. The first one was asked by Mr. Atef Ahmed, and I guess Stanislas Adam could answer this question, but it's of course open to other speakers. Do you think the multiplicity and diversity of global human languages, such as the uniqueness of the language and the legal terminology used in Arabic language or even other languages, will have a negative or positive impact on cases when employing AI in courts? And I guess Smita can also answer this question, given that you mentioned the 122 languages in India.
It's a very difficult question. All that I can say here at the court is the multilingual lingual environment can be a source of enrichment, of course, comparing how concepts are translated and used in different languages, but they can also be a source of mismatch and a source of confusion. So that is why human oversight on results of outcome of AI applied to or for the purposes of translation or interpretation shall remain important. Of course, I received another question right now, to which I have not answered, I have to say, but I've seen that someone raised the point, but how can you reconcile human oversight with the very purpose and objective of AI, which is, of course, gaining efficiency? I have no clear answer to that, frankly speaking. I suppose that we will have to operate with statistical auditing and probably, I would say, and if we want to go and to opt for more wider use of AI in the future, we will probably have to find ways to combine the two and to arbitrate between the two. But it is clear that human oversight is particularly important to verify the correctness of how a concept that was used, for example, in a reference for a premier ruling in Bulgarian, is translated into Italian. And for that, a human being will and shall probably, at least at this point in time, remain necessary.
Thank you so much. Smita, over to you.
Just very quickly, I want to share on the language piece. There are a lot of efforts worldwide undergoing on creating hyperlocal contextualized large language models, which are actually built on, let's say, legalese. Right, for a particular country as well. And there are such efforts also happening in the medical field and the financial field to allow for these large language models, which are behind a lot of these AI solutions, to actually use some of these languages. So, for example, in Africa, there's an initiative called Lilapa.ai. In India, there's Bhashini. I'm sure there's going to stuff come out in Southeast Asian and Arabic languages as well. Thank you.
Thank you so much. I have another very important question that was asked by Mindogas Triokas, and sorry if I mispronounce your name. Could anybody answer who may, can, and should be responsible for the mistake of AI? If the AI system makes mistakes, who is taking responsibility? Any answer welcome.
It's another question to which it is impossible to answer, I think, in a few seconds. A point which I wanted to make, which may be related to that, is what is human oversight precisely? How do we conceive of it? We have, several of us have mentioned that, and it was also already in the CEPEJ ethical guidelines. If it means that at every single step of the process, everything has to be verified by a human being, we might end up observing that AI does not produce much added value. So, but I think what is very important is, I refer here to the traceability principle in our AI strategy, that one is able at a later point in time to raise a problem of incompatibility of the result with the reality and to correct mistakes that have been made. But for doing this, it's important that we put in place the procedures for doing that we are transparent as to when we use AI tools. That is another principle that is now in our guidelines, and also that we can trace back how the system, the algorithm, has produced a given result. It may sound a bit of a corrective approach, but that corrective approach will definitely have to be developed. Another point, I think Smita and I approached language issues from a different perspective. I was more thinking of the decision-making process, production of the judicial decision, whereas her approach was more on access to justice, which is so she was more thinking, I think, at the input level, how to exceed courts and obtain a solution, whereas, of course, dealing with the Court of Justice and the ultimate interpreter of EU law, I was more thinking about making sure that the answer of the court is understood, is understood and has the same meaning in all member states.
Thank you so much, Stanislas. Ronald, your hand was raised. very briefly, if I may.
Yeah, sorry. And let's not forget how that there's also human error, and there's errors in the entire value chain. So I think as long as we're not talking about fully automated adjudication, right? We are a long way. So it's still very much the people's responsibility that use AI tools, and they're all supporting tools for now. So the responsibility lies still with the users, I would say. And whether you use AI or any technology or even a human, let's say, chain of activities, there will always be errors. We just need to be really mindful. And when it comes to, there was a question around AI in community. Well, we need to be super, I would say, careful in how you train models and make sure they're culturally sensitive, involve the people, make sure they really understand situations. But we should never forget it is a supporting tool that will make mistakes.
Thank you, Ronald. So now we are running out of time, and I'm sorry that I have to end this Q&A session. And despite the active participation of our audience, I just want to thank all of our speakers for sharing their experience, their insights, and their questions with us today. I want to thank our audience for being so present, for being so patient, and for raising many questions that we unfortunately didn't have time to answer. Just one quick information: this session has been recorded and will be uploaded on YouTube, so people can watch this video again. We have raised many questions. We are entering a new era in the adoption and implementation of AI systems, and hopefully we'll have many other opportunities to have this conversation in the coming months. Now I want to thank you, everybody, and wish you a good rest of the day or evening, depending on your location. Thank you so much, everybody.
Thank you.
Thank you.
Thank you.